Imagine walking into a courtroom, accusing the judge of a 10-year-old personal vendetta, calling the official police citation a fraud, and then top it all off by firing your lawyer before the trial even starts. This is exactly how self-represented defendant Mr. Blandino decided to handle his battery arraignment in Las Vegas. He thought he could outsmart the legal system with big words and conspiracy theories, but Judge Kelly Giordani was about to show him exactly what happens to defendants who mistake a courtroom for a circus.
Okay, sorry.
So you were here, hold on, sir, let me start, okay? You were here for arraignment. I did review the jobs from your time in front of Judge Walker last week. So it appears he made you aware of the battery. You confirmed that you received a copy of the citation. Is that correct?
No, I did not.
Okay, I saw you hold it up on the jack, so did
But
you
that's, it's a fraudulent document. They altered the document. I need to look at the file.
So
But
Mr.
first,
Blandino,
would you
I'm
let
gonna
me-
stop you right now. Okay,
First,
so
would you let
I
me enter
talk,
my
sir,
appearance? Would I
I'm
enter
gonna
my
tell you
appearance?
once, I talk first, you talk next, okay? We're gonna just set a tone of decorum here so that we can have a successful
We need
conversation.
also to make a record, Judge.
You will, when not when I'm talking, okay?
All right.
So I talk first. So did you receive a copy of this citation? Because I saw you hold it up in the JAPS video from last week. And I know you might not agree with its authenticity or have issues with it, but did you in fact receive a copy?
This is the NCR citation I got.
I see
They
you
altered
have a
this
copy.
document.
Let's pause for a second. This hearing is an arraignment. Legally, this is just the initial step where the court informs the defendant of the charges and reads their rights. It is not the time to argue evidence, cross-examine police officers, or claim the documents are forged. But instead of entering a simple plea, Blandino immediately derails the protocol by claiming a massive police conspiracy.
So, based on that, City, are you seeking?
Yes, Your Honor.
Okay. Did you fill out the public attorney paperwork for me, Mr. Blandino?
No, well, I did. I left that at home, but I'm not going to follow through with that. I've got,
Okay, so do you plan to fill out public attorney paperwork? Do you plan to hire an attorney or do you plan to represent yourself?
what I plan to do, if everything gets squared away, is it my time to make a record now?
I want you to ask my questions first, and then I'm happy to give you time to make whatever recommendation. So do you plan to fill out the public attorney paperwork, hire your own attorney, or represent yourself?
Neither. I plan to represent myself and ask for standby counsel.
Okay, then I need you to fill out a copy of the Faretta canvas.
The judge just mentioned a Faretta canvas. Under the landmark Supreme Court precedent Faretta versus California, a defendant has a constitutional right to refuse a lawyer and represent themselves. However, the judge must force them to fill out a strict questionnaire to ensure they fully understand the extreme danger of going to trial without a professional. It's a warning system, but Blandino views it as a personal attack.
Which I believe we attempted to give you this afternoon. So did you fill that out for me, Mr. Blandino?
I'm sorry?
Did you fill out the Faretta canvas that my marshal
No, I
provided
did
you?
not.
Okay, then we're gonna go off record. I'm gonna have you fill that out, and then we'll talk about it in a few moments. Section 5437, I'm in receipt of your Faretta canvas.
I'm sorry, you're talking to me? I can't hear you.
Mr. Blandino, come
Yes.
on up to the podium, please.
I couldn't hear you there, Judge.
Okay, I'm in receipt of your Faretta canvas. And it looks like based on your answers, although you didn't sign it, I know you filled it out, so based on that, I will appoint you to represent yourself. I'll grant your Faretta request. Just as a point of clarification, as I went over before you filled this out, when we took a brief recess, if you represent yourself and you want standby counsel, that's fine. You just have to bring your own attorney. I'm not gonna appoint the public attorney to represent you unless you choose for them to fill out the paperwork and for us to go through that analysis. So would you like to fill out the public attorney paperwork, or would you like to just represent yourself and bring your own attorney as standby counsel?
Well, see, Judge, I've got, it seems like you're really trying to bully me here, and it's not appreciated. I know you have some deep-seated antagonism toward me because you prosecuted me before.
I'm gonna stop you right there, Mr. Blandino.
Yeah,
I've never prosecuted you before, okay?
I've got the court documents.
What's the case number that you are alleging I prosecuted you under?
You were in the prosecution, and I don't have the case number in front of me. My printer went out, and I don't have it. I got a bunch of gibberish on the thing. I barely printed out this notice and demand that I had filed. To see all the lines there. My backup printer went bad.
The classic excuse, I have proof, but my printer broke. Blandino tries to accuse Judge Giordani of prosecuting him a decade ago, alleging deep-seated bias. In the legal world, if a judge was a former prosecutor on a defendant's past case, it could be grounds for disqualification. But notice how smoothly the judge handles it. She completely shuts down the drama by demanding a case number, which Blandino conveniently doesn't have.
Okay.
And so it's
If you
all
want to
good.
provide me in the future with a case number where you believe I was the prosecutor who prosecuted.
No, it's not a question of
Hold on,
belief.
sir.
It
As I
was-
told you before, when I talk, you don't talk, and when you talk, I won't interrupt you, okay? Just so we can make a clear record. If you have a case number that you can provide to me, I would be happy to review it. I have never prosecuted you on the cases that I can think of that you've had in the city of Las Vegas, either in my time as a city attorney or in the appellate division, so I don't believe
You
there
didn't go to
that's-
trial, but you were the prosecutor, and it's got your name clearly listed on the documents on the portal.
And again, sir, hold on, I'm happy to review it if you provide me with the case number. As it stands right now, I don't believe I have any reason to recuse off the case, and I'm not going to do so if that is your request, because I've never done that in regards to participating in a trial against you being the prosecutor, like Judge Walker had, okay? So again, back to my prior question, would you like to be approved to represent yourself and bring your own attorney, or would
Judge, you are not letting me make a record. I am here by
Blandino,
special appearance.
we are not
only.
gonna do this, sir. We're
You're
not
not
gonna
gonna
do
do
this.
what? No, you're not gonna let me make a record?
There's certain things we have to get through.
Judge, I'm gonna file a motion to disqualify you. Are you assigned to this case?
Mr. Blandino, I'm going to
Did you
tell
assign
one
yourself to
last
this
time.
case?
I'm going to tell you one last time that when you are in my courtroom, I'm happy to listen to you and for us to have a conversation, but it has to maintain a respectful tone. If you're going to raise your voice at me or be disrespectful, our conversation is going to end. So would you like to take a moment, or would you like to keep talking?
Is it my turn to talk?
The answer, you're going to answer the questions I have, sir, so that we can get through this arraignment process. Would you like to take a moment, or can you proceed without raising your voice at me?
I wasn't aware that I was raising my voice. I'm using my normal voice, Judge.
No, sir, you just yelled at me, and I'm not gonna allow that in my courtroom, okay? So let that be an admonishment to you. Let's go back to the original question. Would you like to represent yourself and bring in your own attorney, or would you like to fill out the public attorney paperwork?
In order to answer that question, I need to know if the prosecution is seeking jail time.
And Miss, I believe Liz was here prior, and she stated yes.
You are seeking jail time.
Correct, City? Either suspended or actual. I don't participate in the negotiation at this point, but are you seeking actual or suspended jail?
Yes, Judge.
Okay.
So the
same-
maximum penalty is on this charge?
A maximum penalty for misdemeanor in custody is 180 days. Okay, and we're talking in custody.
Because allegedly the charge is battery. Are you aware of that?
I am.
So that's 180 days maximum penalty?
If we're talking in custody, yes, sir.
So that's 6 months.
Yes, sir.
Okay. So now that I know the jeopardy I'm under and that the prosecution is seeking jail time, then under all the case law that I've seen, I'm entitled to represent myself and have standby counsel appointed at no expense to me. I will be filing, if you allow me, I will file an IFP under seal. I've had death threats because of these last court appearances. I had somebody that made death threats to me, and I need to file an informal pauperous status application, pauperous status application under seal.
Okay.
And so, but the thing is, I'm here by special appearance only. I need to make that clear. I've asked to look at the file, you denied it. I've told you that there's been documents that have been altered on these
Just for
originals.
clarification, I haven't denied any requests you've made thus far. We're
Okay.
just trying to get through the first couple questions, Mr. Blandino, and it's the same questions I ask everyone that come before me, okay? So you and I believe, are talking a bit in semantics right now. I know you filled out the Faretta, I know you want to represent yourself. In order to appoint the public attorney by our municipal court policy, you have to fill out the public attorney paperwork. If you want me to keep that information confidential, which we always do, the only person who receives that information is the public attorney herself. I'm happy to do that so that you don't have to go out and file your own informal papyrus under seal. But in order to make that analysis to appoint her and then get to the point of the conversation where we allow you to represent yourself and make her stand by, I need you to fill out the public attorney paperwork because it's what everybody who wants the public attorney to be appointed does in municipal court. So would you like to take a moment to fill that out or no?
Well, the way you put it that way, there's still some questions that arise. First, I'm not everybody, I'm nobody. You said everybody does it. I just pointed out to Thompson that second question on the Faretta canvas, nobody's ever questioned anything before, but nobody here is here questioning it now. It says, how far did you go in school, yes or no? What kind of question is that? How do you answer that
You
question?
know what, that's a good catch, and it got sent to our supervisor, and she's in the process of changing it, so thank you.
So you realize that this form is incompetent
No,
as
sir, I'm not gonna make that finding, and I don't wanna go back and forth. I just want you to answer my simple questions that I'm trying to pose to you so we can get through the arraignment process, okay?
That's the
Would you
problem.
like- Would you like to fill out the public attorney paperwork so that we can talk about whether or not you qualify for the public attorney services? Then we can go down this whole road that we're talking about on whether or not she's standby or she represents you or how you'd like to proceed. But the steps,
I
and I
can fill
don't.
that form out. You want me to fill it out right
If
now?
you-
But
If
there's
you would
another-
like her to be considered to be appointed to your case, then yes, sir, you have to fill it out. Okay, so would you like me to trail your case for a minute while you do that?
You know, I had it at home and I don't know if I have a copy of it here. My printer messed up, so I had to copy and rescan stuff.
We have plenty of copies. Again, it's something we have to do. As you know, the Supreme Court gives us outlines that we have to abide by in reference to whether or not people qualify. So I request that information of everyone who is requesting the services of the
But
public.
if I may, Judge, the order by Judge Walker, a written order, I demanded a written order and he agreed to that request or that demand. He said it was being transferred here for calendaring. My understanding was, despite what any preformed, postcards or things might say, which, I'm under threat of warrant if I didn't come here. I was under threat of warrant if I didn't go a week ago to Matthew Walker's courtroom. And he said this is for calendaring. He says it's up to you whether you were going to assign somebody at random or assign yourself. So the first order of business, you come up in here and you say we're doing an arraignment. I don't even know if you've assigned yourself to the case. Am I to understand that you've assigned yourself to this case?
Yes, sir. This
And
case
you
will
did
remain on
not, why
purpose.
did you not do it randomly? Why wasn't it not randomly reassigned?
Because recusals go to the chief judge.
I'm sorry?
So a recusal goes to the chief judge, and I am the chief judge. So it came to me. If I had something that would require me to recuse off of this case, I would then randomly reassign it, but I don't believe that I do, so I will keep this case.
Well, then in that case, because I have, according to NRS 1.230, 1.235, once you now say you have assigned yourself to the case, I have 10 days in order to file a motion to disqualify because of the deep-seated antagonism that has been carried over from some 10 years ago when we met, had conversations in the hallway, and you expressed some deep-seated antagonism toward my religious beliefs and practices.
Blandino pulls out Nevada Revised Statutes 1.235, giving him 10 days to file a formal motion to disqualify the judge. He doubles down on a wild claim that the judge insulted his religion in a hallway 10 years ago. It's an aggressive legal maneuver, but a dangerous one if you can't back it up with absolute proof. Watch how the judge remains completely unfazed.
No, sir, I'm gonna stop you there. I have never done that. I respectfully disagree. So unless, again, you're able to provide me with specific instances, that's cases where I prosecuted you or other things, and listen, Mr. Blandino, you're welcome to file whatever you'd like.
It will be in the motion.
But we are going to go through the arraignment today.
It
So
will
let's
be
go
in the
back to
motion.
the first question that I've been trying to get an answer from you for. Would you like to fill out the public attorney paperwork today so we can go through the analysis of
I
whether or
will.
not they're appointed?
I will fill that out if you like, but I'm just telling you that it's
Sir,
under special
it's your
appearance.
question. Would you like to fill out that paperwork today so that I can go through the analysis of whether or not to appoint the public attorney?
I did say yes.
Okay, have a seat for me, fill it out, and let me know
But
when
I
it's done,
still need,
okay?
I'm still needing to
Have
make
a
a
seat for me,
record.
Mr. Blandino. We're going to get through the initial steps of the arraignment before we let you make a record.
I'm
So
fine.
please have a seat.
I'm asking
I will go
for,
through.
let me ask for my
Sir,
continuance.
I'm not going to tell you again. Please have a seat, fill out the public attorney
Judge.
paperwork, and we will go through the analysis.
I object, Judge.
Thank
You're
you,
trying to
Mr.
bully me,
Blandino.
Judge. You're
Appreciate
trying to
that.
bully me, Judge. I
Let's
object.
bullying, sir. Please
I
have a
object.
seat, fill out the paperwork.
The declaration does not apply. I'm gonna have to make up my own form and get it to the court.
Based on the information that you provided, and the fact, again, are outlined by the Supreme Court, the public attorney is appointed. We can go through the analysis with the public attorney present on what you would like to do in reference to whether or not you'd like them to be standby and you predominantly like to represent yourself. As I said earlier, I am your seat of your Faretta, so Procedurally, from the arraignment, we have touched all bases. You said you wanted to make a record, so please go ahead, Mr. Blandino.
All right, and it may take some time. You're here under NRS 5.021. You're the chief judge. That's the statute that governs what the chief judge's duties are. I've got something that I need to file in open court that I tried to file, told you had computer problems or printer problems, which it did. You had all these different lines in there. I couldn't pull out. I even used my backup, both my backup printer and my main printer, putting these lines on there and then giving me all kinds of blank pages with lines, okay? I'm here by special appearance. I want to make that absolutely clear. The judge's order, Judge Walker's order, he disqualified himself. This was supposed to be for calendaring today. So you're trying to jump over some procedural hoops, some due process. You know, shortcuts are fine. I understand you got an assembly line going. You're like Laverne and Shirley here, but sometimes the bottle cap doesn't get put on the bottle. You've given me inadequate forms that apparently for some time, this looks like it's issued 9/21/22. And for the record, if it wasn't caught before, how far did you go in school, yes or no? That's not a yes or no question. This form is clearly flawed and it should not be going forward. It says, question 17, do you know the elements of these crimes, what the elements of these crimes are, and then in parentheses, ask the defendant to explain what he thinks the elements of the crime are. This is stage direction to the court in which they're supposed to be asking these questions. I believe it's Nevada Supreme Court Rule 251 or 252 that requires a Faretta canvas whenever there's any threat of jailing, which there is clearly in this case. The city is admitted to that, but they want jail.
And for the record, Mr. Blandino, I read through your Faretta canvas myself, and so I'm making it as a judicial officer, having read both page 1 and 2 that you confirmed you filled out based on the information provided, that based on Faretta, you are competent and able to represent yourself. Okay, so that's the court's finding in regards to that.
Well, the standard is...
What else would you like to talk about today,
Well,
sir?
the standard is actually voluntarily and freely given, and that's the standard, not competently. You can actually be incompetent and still be allowed to represent yourself. But the thing is that, let me see my notes here. I've come 4 separate times to watch the courts and different things, and I've let you know about this situation that we had prior to, and I couldn't print that document out and have it today. But I mean, it's clear that you're showing this deep-seated antagonism toward me, and commensurate with 1.230 and 1.235, I got to file a motion to disqualify you. And you may disagree with the basis for that, but there's 4 different standards.
All right,
Actual
we're not going to get into
bias.
that right now, Mr. Blandino.
Okay.
No, we're not going to get into that. As I told you,
All right, but I am...
Hold on. You are free to file whatever motion you would like.
Yeah.
Okay, whatever information you would like to provide to me that would suggest.
Can we file this in open court
Hold on,
today?
sir, please don't interrupt me.
I'm sorry.
Okay? Whatever information you would like to provide to me that suggests that I should not sit on this case because I'm biased, I am happy to review. And as you know, and you know very well how to file motions, you are welcome to do all of that. For our purposes today, we have touched all the things that we need to. I'm going to set this for a pretrial hearing in 30 days. Between now and then, you can file whatever you'd like to file. You can also get a copy of discovery if
I want
you'd
to file
like.
this in open court.
City, okay, hold on one second, we'll get to that in a second. I know that typically if the public attorney is appointed, we provide, or your office provides all discovery to the public attorney. I'm asking that in this particular case, Mr. Blandino also be given the opportunity to get discovery as opposed to it going straight to Ms. Toole and then have to be provided from Ms. Toole to you. Okay, so in this particular case,
You're talking too fast, Judge. I cannot make all that.
and I'm talking to the city. So do you have any objection to that?
I have no objection. I'll send an email to our front desk.
I have an objection.
That
So-
Mr. Blandino will likely be coming by requesting the discovery.
I appreciate that accommodation. So sir, if you'd like to write this date down, I'm gonna see you back on March 18th.
I'm sorry, Judge. I still need to make a record. Can I file this in open court?
Hold on, sir. Write this date down for me, please. March 18th, 2026. March 18th, 2026 at 8:15 a.m. Now, for the record, what are you trying to file in open court? Because what is our typical policy on accepting
Well, first I want to know,
1 second, let me just hear from my clerk over. So you need to file that downstairs on the first floor, okay? So before you leave the building today, just go down and file it on the first floor.
I tried to file it this morning, the clerk said they need 3 copies, and I only have 2. One for myself and one for the printer.
Okay, so
I mean, one-
apparently the issue this morning was that there was no line in e-court to say pro se. So we're gonna note it on our end, which allows you the ability to file it on the first floor, okay? And then when it comes to copies, how does that work?
I believe they give them,
They'll scan it, they'll provide a copy.
and they have to come with copies of there.
Okay, so in this particular case, can we send an email to the front counter that suggests or requests that we scan it and then provide, we'll get an electronic copy and the city will get an electronic copy. In the future, it is your obligation though that you have to bring copies for everyone if you want to file. But today I'm happy to make that accommodation for you, okay? Any other questions for me? I understand you have a lot that you want to say for today's purposes.
No, I don't have questions, but I need to make
I
this
understand,
record.
but
You
now-
just assigned
Sir,
we're
hold on.
clear, Judge.
Your attorney is not here, and we're not gonna get into substantive issues about your case or your position on the case until your attorney is here. So we're gonna do that on the 18th.
Wait a minute, I'm representing myself as standby
Sir,
counsel.
I appointed the public attorney and told you on the next date when your attorney is present, we will
Oh,
talk
no,
about how that
No,
works.
we gotta do a Faretta canvas, because I do want to
Sir.
represent myself with standby counsel or not have representation. So if you're gonna give me the choice
Hold on,
between.
Mr. Blandino, I asked you that question probably 8 times, sir. I told you that in this particular case, if you would like the public attorney to be appointed, then you have to fill out the paperwork and we have to go through that analysis. You don't get to choose who your standby counsel is
Okay,
or
then-
how that works. Hold on.
And here comes the absolute downfall of his entire strategy. The judge actually grants him a public defender based on his financial paperwork. But because she won't let him dictate terms or force the lawyer to act strictly as standby under his commands, Blandino lets his pride take over. He completely rejects the free legal help, opting to face a potential 6-month jail sentence entirely alone.
I make that determination based on a variety of factors. So today you asked for the public attorney to be appointed, you filled out the paperwork, and I appointed them because you qualify. If you don't want
I did not
standby,
sign that paperwork.
sir, if you do not want the public attorney to be considered as your attorney today, as I told you earlier, you are welcome to represent yourself, but if you are seeking standby counsel, then you will have to provide it at your own expense. So how would you like to proceed today?
I'm representing myself then, no standby.
All right, so we will revoke the public attorney as attorney of record at the request of Mr. Blandino.
You're talking too fast for me,
And
Judge.
in reference to the Faretta canvas, sir, as I told you earlier, I had already granted that before we went through the analysis, so I've read through the Faretta canvas based on how far you went in school and all of your answers. I feel that you are able to represent yourself. For today's purposes, we are still only going to go through these things. So you can pick up your discovery at the city attorney's office or however they want to distribute to you, whether it be electronic, because I know they have an e-court system, or you want to pay for a paper copy. You can file the motion that you have, and I'm going to keep the same pretrial date to give you the opportunity to do all the things that you need to do in the next 30 days. Okay?
Wait, Judge, I still need to make a record. You assigned yourself to this case today. I'm filing a motion to disqualify you.
And that sounds great.
And as
so
soon as
all
that's
the motions-
filed, you cannot do anything
Sir,
else. You need
all
to
the
know
motions you
that.
need to file, you file them, and they will be scheduled on our motion calendar. For now, the next date you have in front of
You
you right now
cannot hear your
is
own
March
motion to
18th,
disqualify you.
2026 at 8:15 a.m. Thank you, Mr. Blandino.
Mr. Blandino wanted to make a statement, but instead, he walked away with no attorney. A looming trial date on the 18th of March, 2026, and a judge who is now fully aware of his games. He tried to weaponize the law using typos and decades-old hallway gossip, but the court process moved forward regardless. Was he a brave man fighting a broken system? Or just an entitled defendant digging his own grave? Let me know your verdict in the comments below. Smash that subscribe button for more breakdowns, and we'll see you next time on Law and Court Explained.